All right, good morning, everybody. This is a combined meeting of PASHA and IASIU DelVal chapter. If we start the meeting, if you could please rise where you're at and display the flag for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so we'll start out with the Antitrust Act. As members of this organization or participants in this meeting, we need to be mindful of the constraints of the antitrust laws. There should be no discussions of agreements or concerted actions that may restrain competition. This prohibition includes the exchange of information concerning individual company rates, coverages, market practices, claim settlement practices, or any other competitive aspect of an individual company's operations. Each member or participant is obligated to speak up immediately for the purpose of preventing any discussion falling outside the bounds indicated. So we're going to deviate from the normal business. So at this time, I'm going to call up Doug Babin from PASHA.
A little bit different environment today. Ooh. Maybe I should have wore a jacket, but thank you all. I want to thank Bob Worst for letting us enjoy his conference room and his facilities. It's a great spot. I'm glad everybody could make it. This is a combined meeting. Al, thank you for setting it up and doing everything that you do for NICB. I'm just going to be quick because we have a lot of speakers today. Our next meeting, we already sent out the invite. Deb sent it out October 3rd. At Knights of Columbus. We're going to do a mini. We were going to try to do a full mock trial, but it just became too much to try to condense in an hour. So we're going to do a mini mock trial, and we're going to do ARCA, and we're going to do like a missed claim, stage cause accidents type claim scenario involving ARCA as our expert. So it should be interesting for everybody. So back in the day, you can see the gray hair. So from 1997 to 2012, I did work Philadelphia quite a bit. And I want to get back to showing everybody that it is possible to try cases in the Philadelphia area. I know a lot of people I hear and talk about, you can't try a case in Philly, you can't try a case in New York. You can. And we used to win these cases. And I think that many insurance companies are getting away from trying cases. They're more in the aspect of saving expenses, and I get that. But let's get back to trying cases when needed or when applicable. So October 3rd at Knights of Columbus. And then our next meeting after that is 11/7/2005 or 2025. Jim Cole from Marcia Denny, he's going to give us a presentation on arson, title, and leasing fraud. So those are our next two meetings, and then we're going to have a combined meeting in Christmas time with IASIU like we always do. So make it brief. Thank you all. And again, thank you, Bob, Al, for setting this up. Thank you all.
All right, at this time, we're going to ask Al to come up and give an NICB update.
Okay.
Oh, wait, hold on. That's right. I'm sorry. James Ryman's going to give a update on some cases.
Good morning. I'm Jim Reeman with USA Insurance. Just wanted to share a couple of cases that came across my desk with the group. It has to do with some of the tow contractors we've been dealing with in the area, and I also have a case out of Allegheny County. And I did clear this with this is all public record. These are criminal charges brought against these individuals, and I cleared it with Bob from a legal standpoint so far as sharing it with you. But it's good news, so it's information I certainly wanted to share with everybody. I had testified in a case against defendant Garnell Atkins. He runs Pit Stop or Pit Lane Towing out of Warren Street, and he was indicted on 9 counts, including forgery, conspiracy, insurance fraud, and other related counts. So that, to me, I went to the preliminary hearing and I testified, and the judge held all 9 counts over. He didn't throw out anything, and it was a good result. And it's good to know that the DA's office is taking this position to take this action against these perpetrators. Diana Adamczyk was the prosecuting attorney. I worked with Joe Kent, who a lot of you know, at the Auto Squad in Philadelphia. And in my particular case, the defendant had taken the car off the street while the USA tow truck was en route to the accident. So that gave a little more strength, but I wouldn't be discouraged, but have any of you be discouraged about bringing these cases to the attention of the district attorney, to the Delaware County guys, the Bucks County. it shows what can happen when we stick with it, and the charges get filed. So the defendant is coming up on trial. I don't know how it will play out, but I'll leave it at that. It is a case that was brought in Philadelphia. A second case I want to bring to your attention. We had a speaker, Detective Keith Cicotti from the Allegheny County Prosecutor's Office. He may have mentioned this individual. The defendant's name is Vincent George Fanek. He runs Vince's Towing out of Pittsburgh. That was a 115 count indictment that was filed against him. So Keith had done his due diligence and his investigations. I know I was contacted about some USAA claims. Maybe some of you have been contacted by him as well. But again, those were charges that were brought against him. I believe that case is coming up for trial. I don't know a specific status, but again, you're putting in the work, or somebody is putting in the work to indict someone on 115 counts. That means they want to see some action on it, and they want to see it come to fruition. See the fruits of their labor come through. So I wanted to bring these cases to your attention to encourage you to continue these types of investigations or share the information with Al from NICB, with IASIU, with PASHA. Hopefully, from some of our efforts, we can create. It would appear we're creating more of an appetite for the prosecutors to bring these cases, which is, again, that's a good result. And naturally, you would think from the prosecutions would follow maybe more of a deterrence. We want to create an atmosphere of deterrence for these folks, because we all know who we're dealing with, and we can all share our stories, the experiences we've had. But it's good to see that at least these two are coming forward, and I'm sure there will be others in the future. Feel free to share it, with the NICB, with IASIU, with the folks here at PASHA. And thank you for your time.
Okay, so now we'll have Al Quintilli with NICB. Oh, hold on, maybe we should have Bob. No.
Thanks, Bob, again. Beautiful facility. Everything's beautiful here. A couple things briefly for me. SIUs, you're needed to testify in court. So the referrals are coming in, from all over the country. But if it's a Philadelphia or Pennsylvania case, we need someone locally to stand up everything. So remember that when you're, dealing with people, you need to come in and testify for us. As Jim said, tow referrals are still going. Slip and fall stat. Pennsylvania, we're doing a great job. 13% decrease in slip and falls. So over the last 2 years, it's hurricane season. So something bad happens, NICB will be out there. I'll be putting out signs and passing out pamphlets to people to be aware of bad contractors and the things of that nature. Some training. National Conference of Attorneys is going to be happening October 7th and 8th, just outside of Chicago, for that's Zoric's headquarters. So I think it's pretty well attended by some of the attorneys, maybe at the AG's office or whoever the grantees are. Some of those attorneys do show up at that. Matt asked me to mention some medical stuff, medical investigation symposium he's running October 14th through the 16th. It's virtual. There's going to be a panel discussion and some trends and cases they're going to talk about. And then also the NJSIA conference is going to be October 20th through the 22nd. And I think Matt's doing that, and it's going to be on nomadic organizations. So, but again, if you can visit www.nicb.org, you can find all the training, that you're looking for. That's it. Thanks again, guys.
Thanks, Al. And the law enforcement updates will be done by Bobby D.
Okay, for Philly, we have 20 arrests and 6 pending. The AG has 171 arrests, and Delco has 40 arrests with 10 pending. I wanted to touch on something that Jim said, that case out in Pittsburgh is actually going on today. That's why Chris Sloan's not here from the IFPA. From the IFPA, referrals are up and arrests are up from last year this time, so that's good. And the last thing I want to mention is for the towing cases, when you're trying to notify the police that you have a car somewhere, let them know as soon as possible, because especially in Delaware County, they can use the cameras and to their advantage to actually see what happened at the scene of the accident. So if you want to refer something, you have a car somewhere and you want to call the Philly Task Force or Delco or the AG, let us know or let them know as soon as possible. And they can usually get footage if it's from their cameras, if it's at intersection has cameras. So I think that's it. Thanks.
All right, now for some of the DelVal business, we have some new things up and coming. We're going to look at getting a website, look about doing payments online, and we'll be meeting with the board after this meeting here to go over it really quick. Won't take much of your time. Also, we're looking for recommendations for Investigator of the Year for 2025. So if you do have any recommendations, feel free to contact any of the members on the board. Just a small email will do why you are submitting the submission, and just a little summary of the case. I'd like to get those by November 1st. So if you can get those in, again, just email one of the members on the board. So for the December meeting with Pasha, it's going to be December 9th. This caused a problem for the Dream Drive. So Dream Drive needs their gifts by December 6th. So Bob Horst has graciously put together with his firm to get some gifts for Dream Drive. Also, there's a flyer that we'll put out to the membership if you'd like to donate to Dream Drive yourself. But we'll still do a gift for the, if you can bring a gift of $20 to the December meeting at the FOP Hall. That'll be at 10 o'clock, I think we said, on December 9th. And those gifts will go to the Marine Corps Toys for Tots. So I arranged to have a contact with the Marine Corps, and they need their gifts by December 12th. So it'll work perfect. So when you bring the gifts December 9th, we'll give them to the Marine Corps to get them for Toys for Tots. That's basically all I have for the IASIU stuff. I did attend the IASIU meetings out in conference out in Denver. It was very well attended, over 1,000 people and vendors. It felt like pre-COVID time, which was really great to see a lot of people I haven't seen in many years. At this time, we're going to do the legal updates with Bob Horst. If you'd like to come up, Bob, and take care of that.
Thanks, Steve.
Thank you, Dave. Good morning, everyone. It's been requested more than once that we keep this light. So we're going to go for 5 minutes, which in Bob Horst speak means 20. Just kidding. Just kidding. The topic of today's legal update is evidence preservation. And the reason that I think the topic is meaningful has been observations made by some of the lawyers in the industry, not just here at my firm, but elsewhere, regarding what I perceive as the mindset that's far too defensive about evidence preservation. Now, if you're wondering, Bob, what do you mean? Is that a criticism? Well, what I mean is not a criticism. It's an invitation to change your mindset about how you, as an investigator, whether you work for another entity, for an insurer, for a corporate entity, or on your own in private practice, how you approach the concept, or more importantly, the duty that is evidence collection and, as I said, preservation. I'm going to read you a list. This list was published in the August 2025 edition of Plaintiff Magazine. And you're going, what? There's something called Plaintiff Magazine? Yes. And like, any good interested lawyer would be, we're trying to make sure that we're constantly following and keeping up with what the other side of the V, the plaintiff bar, is doing. They've got a publication. It's great to read. There's fantastic lawyering in it. There's an article here from one of the most successful firms in Los Angeles, one of their lawyers. His name's Andrew Owen. I don't know Andrew Owen at all, but I know his article. And this article, entitled Evidence Preservation, opened my eyes to something that I think I'd been considering subconsciously. And it's very simply that when I say we're defensive, we're all worried about, did I preserve this enough to the point that nobody has their rights infringed upon, that we don't lose the ability to pursue an argument in court, we don't get sanctioned by a judge? Did I keep the right evidence? My invitation to you as I read this list is to realize that while being defensive about it can be a successful approach. The more successful approach, I believe, is to simply say, we're going to collect all the relevant information, especially as an investigator, and then we're going to preserve it to the extent the law expects. Here's the list. This is a list generally of what should be collected after a motor vehicle accident when a claim or litigation is anticipated, just reasonably anticipated. Number one, the vehicle itself. You've already got my attention. I'm collecting and preserving the vehicle itself when it's not a total, but okay. The vehicle itself and all component parts. I'll leave out some details. Number two, all data, not some, not the data you can find. It says all data collected in an electronic data recorder, airbag control module, or any other electronic control module capable of recording and storing data. Number three, all media. Realize, again, the word all, a pretty broad one. Media from any dash cam or onboard camera. All GPS data is number four. Number five, all photographs, videos, other digital images. And then number six, all communications relating to the subject collision. That list sounds comprehensive. It sounds really safe. And if you had that defensive mindset, you'd say, this is a great list. But now I'm going to be more specific with you. And this is the reminder, hopefully the takeaway, that when you're collecting evidence, for those of you on camera right now, you don't know. I just looked at Dave Donovan from Hague, right? Dave's only as good as we can line him up to be as an expert. He can only get out to a lost location when he knows there's a loss to look at. He can only collect evidence when he has permission of some owner or custodian of the evidence. If we don't get him out there quickly enough and in the mindset of collecting specifics, not general evidence, but specific things, he's not going to be able to do the job he's otherwise capable of. So the mindset, this list instead is not the general list I said before, but I'll close with what I want you to hear about the suite of technology that's available in a number of 18-wheelers or commercial carriers. According to the article, and I believe it, entities like FedEx, Amazon, National Commercial Motors like CRST or JB Hunt, they all keep a dashboard technology called, and I don't even know if I know how to pronounce it because this was brand new to me from the article, LYTX, LitX or LitX, LYTX. Now read the things that this suite of technology will capture, but that you won't get if you don't know to ask for it. Number one, simultaneously recorded dash and driver cams with accompanying auto. Love to have that audio. Number two, full 360-degree perspective recordings. Three, real-time GPS tracking, including location data by the second and corresponding speed, with steering and braking input. Next, risky driving detection and reports. I did some lengthy driving, Ohio Turnpike, Pennsylvania Turnpike this past weekend. I guarantee some of the truckers that were being clocked this way would lose their job if anyone cared to review the data. Lane changes in front of me, middle fingers extended at me. It wasn't me. It wasn't me. And then last, maintenance. It wasn't me. Maintenance alerts and maintenance compliance. The general list, yeah, it makes a lot of sense. Imagine your counsel or you send out a notice saying, we want you to preserve evidence and use the general list. Everybody would say you were doing your job as an investigator. But when you use the specific list because you know it exists, that's when you're truly preserving the evidence. That's when the claim or the litigation is going to get to its merits much more quickly, and you're going to make your experts empowered to do an even better job for you. Today's message from the legal update, very simply, evidence preservation is a duty. It's fact specific about when it's triggered, but know specifically what you want and what needs to be preserved. That's when the battle's won. Thanks very much. Thanks, Dave.
I got a question for you.
For sure.
We had a lot of investigators in the room. Do you have a recommendation on notes that investigators take and how long to hold them?
Dave's question, if you didn't hear it very simply, is do you have a recommendation for investigators about notes to take, how long to hold them? And I'm going to give you that conservative defensive mentality to start with. If you take notes, save them, because there's going to be an inference if you didn't save them that you somehow spoiled the evidence, what the lawyers and the judges love to call spoliation of evidence. And you don't want to have that implication arise from your conduct. So if you took notes, save them. But Dave's question is a little more insightful, and it was very simply, well, should we be taking notes? That's when I think the mindset changes a bit from don't be so defensive. If you are, don't worry, oh man, I took notes, somebody's going to look at them someday. There's nothing wrong with that. Stand tall, be proud of the investigation you did. If there's a negative inference related to the notes that you took, I think that's a risk worth taking, because I don't know about any of you, but when I don't have notes, my memory's not nearly as good as when I do. And when I don't have notes taken contemporaneously, my notes aren't as trustworthy. I like to take good notes. If somebody eventually needs to see them because a judge said they could or the law says they could, in my opinion, that's okay. Some folks may disagree with me, and I respect that, but I'm a big believer in comprehensive note taking. You may need to review those notes later. Don't be afraid of it. Go ahead and do it. Sound good? Yes, Bob.
Is it possible you can share that article? Is that only like a subscription article?
I do not get the impression it's subscription only. I think it's copyrighted, but I think I can share it. At the very least, I can share with you the content about what those requests are. I'd be happy to do it. I'll make sure that the organization and I don't violate any copyright principles, Bob, but I'll get that to you. Bob DiFrancesco is asking about the content. I'll make sure if you want it, you get it, even if I have to get the author's permission.
Another question, and kind of on what Dave was talking about. A lot of times we use experts to collect information for us and potentially hold evidence, right? And generally, we're paying for them to hold the evidence for a period of time. From a claim perspective, let's hypothetically say we've denied the case because there's been some sort of either misrepresentation or falsity, right? And then, of course, it's going to prosecution. We're still continuing to pay for holding of that evidence, so to speak. How long should we continue doing that while prosecution continues? Most cases, my perspective was always keep it until the case is over.
Yeah.
What's your thoughts?
Andrew, I think that's a great summary that's very safe and therefore effective. Meaning, and if you didn't hear, Andrea is basically saying, how long do we hold this evidence that we're preserving? And she used a phrase I like a lot, until the case is over. We could also say until the claim is over, which may be a shorter period of time. But with that said, that's a safe approach. We would never want to deviate from that safe approach. Preserve it. However, I think if you pay some attention, as Andrea is implying by her question, to maybe we don't need to hold this anymore. Consider the storage charge on a vehicle. It really can increase in cost and burden pretty substantially. We all know this. Well, I think if you just keep a close diary and open communication with any of the other parties, whether it be, let's say it's a third-party claim you're looking at and your insurer insures policyholder Jones. Jones may have counsel. I'd be in touch with Jones's representatives and counsel. Let's say Smith sued Jones. I'd be in touch with Smith's lawyers and representatives, asking very simply, is there a reason that we can't destroy or otherwise discard this evidence? Because remember, the original is much more trustworthy than a copy, period. If you want to send me a photograph of something, that's usually very trustworthy evidence, but it's not the same as what's depicted in the photo. Pictures of the auto, video of the auto can be very useful, but it's not the same as the auto. I say that because in answer to Andrea, I think when you ask the right question, and the right question being not necessarily how long do we have to hold this, but instead, can I destroy this? In fact, I've enjoyed many times the burden being shifted over to someone else who maybe I want to look at that. Well, okay, you have a legal right to look at it. We're going to preserve it for another 30 days. Then it's going to be discarded, destroyed, or otherwise just let go back to 30 days is a commercially reasonable period of time for a vehicle inspection. The answer to Andrea's question, in my humble opinion, is tell everybody that could potentially be involved, we're keeping it, but we're about to get rid of it. If you want to look at it, come look at it. And if you don't, it's at your own risk. But I don't think necessarily, unless an expert tells me that I need to save originals beyond the time that everyone's already looked at them. No rights are forfeited. Jim Riemann also said something important when he was presenting very simply. All of the proceedings that he was talking about involve people that have not yet been proven guilty at trial and have not yet taken a guilty plea, if they will. innocent until proven guilty. However, everything Jim said was factually accurate. Thank you. Thanks, Steve.
And again, well over 5 minutes. Just so we note that. So just with the IASIU stuff, again, I forgot to mention, if anybody would like to be on the board, usually we have it in June, but if you're interested, please contact one of the board members. We'd love to hear from you. Don't forget December, bring a gift. December 9th, 10 a.m., FOP. We'll have breakfast, lunch, and probably some drinks afterwards. After this meeting, we'll have food that is being provided by NICB. Thank you, Al, and NICB for that. And thank Bob Horst for inviting us to his beautiful office. Very glamorous. Right now, we have Dave Donovan from Hague is going to present on property damage claims. He'll tell you a little bit about his company and what they do. So, Dave, take it over. We're going to move this chair for you. This up. Get that in there.
All right, good morning. My name is Dave Donovan. I'm a civil structural engineer, forensic engineer with Hague Engineering. This is the flyer that Dave Coyne had sent out. I give thanks to Dave Coyne and HKR for inviting me here to present. A little bit about my background. I graduated from Lafayette College in Easton, Pennsylvania in 2003 with a Bachelor of Science in Civil Engineering. Here is my employment experience. Started off as an intern early in college with PennDOT. Actually interned with a legal corporation, a law firm. Was interested in that a bit. Out of college, I started with the municipal engineer, night engineering, reviewing municipal plans for developments and such. So I got my experience learning properties, sites, commercial, residential, everything, every aspect of them, utilities, buildings, and such. Moved on as a project manager with Robert Blue Engineers, that's in Bluebell, as a design engineer, designing the civil structural drawings for sites, commercial, residential, industrial, and all the layout of land and everything involved, utilities, structures, etc. From then I was more interested in getting involved with forensic engineering, moved to EDT 2011, and I started there. So I've been doing forensic engineering now for 14, 15 years. Now I'm with Hague Engineering. My private civil engineering interests are geotechnical, such as subsidence, retaining walls, sinkholes, pilings, bulkheads, and foundations, hydrological, which involves flooding, dams, pipes, stormwater management, and such, and structural, buildings, bridges, and towers. So I was invited to come here and talk about opportunistic claims, fraud, if you want to get to it. Building owners, building representatives can become very opportunistic, either from when a hurricane comes through, when they have issues with their property, and then they're claiming some interesting things with the property. During this presentation, I'll discuss the details of several case studies involving a multitude of property damage claims, where the exam, review, file materials, and research of the site data didn't match the story. The scheme that they were presenting was the ruse, or the events of the property owner or the representative were describing. I'll discuss how we performed our thorough analysis and ruling out unreasonable mechanisms of damage, along with the subterfuge or the deception, and then using all that to determine the causes of damage or the incidents to a reasonable degree of engineering certainty. Now, here's the basics, the things to look for when inspecting claimed property damage. Conflicting information from varying sources, interviewing the owner, the tenant, owner's representative, contractors that are involved with the property, eyewitnesses, interviewing all them, reviewing depositions, finding conflicting information, things that aren't consistent from all the varying people involved with the property. Visual appearance of damages gives clues. Aged, is it new? Is it fresh, sharp, rounded, linear, creased, weathered? Example, there's a crack. Is it bright? Are the edges bright? Are they dark? Proximity of damage related to where the reported incident took place. For example, a vehicle impact, a tree impact. Is the claimed damage far away? Is it close? Is it inside or outside the energy dissipation path? So when a vehicle or a tree impacts a structure, the energy of the impact is transferred to that structure. So if a tree impacts a roof, that energy is transferred downward from the roof to the foundation. So you may have cracks in line with that, or you may have claimed cracks on the other side of the building outside the energy dissipation path, which don't add up. So you look for all those related to incidents such as impacts, fire incidents, lightning strikes, etc. Modes to check site data collected. Photographic evidence by others. Our own photos that we take during the site inspection, photographs from a contractor, from an owner, a real estate corporation, prior tenants, or municipalities may have photographs of the property. Video surveillance recordings. Used to check and verify claimed accident or incidents. If you have clear videos of the site during a claimed incident that can dispute their claim, that is very valuable. Evaluate property conditions at the time of the incident versus current conditions. Research online data. Google Earth Maps provide excellent images. Connect Explorer is another valuable tool. Eagle View, then you can get street side images, aerial images, oblique images of the property that are timestamps chronologically. So you can get an image from 2015, 2018. The incident claimed was in 2020. You can see the history of the site and the conditions that were present at those different time frames. Voice recordings, information that supports or refutes claimed incidents and or damage. If you can get voice recordings of owners or tenants discussing the site, the property, the incident, owner representatives. Here's an example of a video evidence to refute an alleged trip and fall that took place in Philadelphia. This was an actual case I was involved with. Delivery driver for a very well-known company, very large, well-known, probably all get packages from them, walked to the front entrance of a property to deliver a package, but tripped on an uneven walkway. That was the claim. We were able to, through request for information and all, obtain dash cam video inside the delivery vehicle. It shows the delivery driver opening the driver's side door, grabbing a package from the front passenger seat, then exiting the front door. As the driver exited the front door driver's side, by way of stepping downward onto the adjacent ground surface, the driver appeared to fall immediately downward from the doorway, rather than taking any steps towards the property, where they were indicating that they tripped and fell on the walkway in front of the residence, whereas the vehicle was parked in the street and they fell outside the driver's side door from the vehicle in the roadway. So these are examples of online information that provides great sources for your property. Here's Connect Explorer, an oblique image, which is basically a 45-degree aerial angle, so you can get wall elevations, roof areas, and they're timestamped. This one is from down here, April 14th, 2024. And they take these photographs over time so you can compare the conditions of the roofs, of the walls, of the parking lots over time, and how those conditions change, deteriorate. Yet maybe have a storm with claimed hurricane damage in 2020, and you can look at an image from 2018, that damage may be there, so that claim may be not consistent. Here's an Eagle View image where you get aerial images of sites. Here's Citizens Bank Park in Philadelphia, the Phillies Stadium. You can get roof areas for a property over many different photographs. And this is good to get quantify damage for a property. Here's a street sign image from Google Maps, Google Earth, Google Maps of a restaurant in Skibback, PA. This image is from August 2019. As you can see in the bottom here, there's images taken over time, November 2008 through March 2023. So you may have a claim somewhere in March 2021 claiming a vehicle impacted this property here and caused damage. And then they claim a crack over here. Well, you can use this imagery, go down the road, and that crack, and if you find that the crack was there then, that's not very consistent. And that's so here's a case evaluation procedure. Review site and or structural background information for the property. Obtain and review deposition transcripts of claimants, witnesses, property representatives of all sorts. Conducted site inspection, obtain data, photographic evidence, measurements, meter readings, moisture meters, any other type of meters that you would use. Secure evidence, any and all evidence that's necessary. I'm also a fire investigator, so I'm involved with fire scenes and collecting and securing evidence for that. Interview property representatives, eyewitnesses, contractors, anyone that you think is relevant and important. Obtain and review video surveillance footage, obtain and review aerial and street side imagery, and compare all the data and research materials obtained with deposition transcript details and property representative interviews, and see if they jive, if they're consistent, where the conflicting information is, what seems like somebody's trying to play a game and is fraudulent. Now we'll look into some case studies involving subterfuge and ultimately fraud of property claims. Here we have a basement of a property that claims a sudden pipe rupture of a sanitary sewer pipe. Here you have not a very good repair fix here or attempt. You have the pipe section identified as a trap that had been covered with materials including duct tape, roofing mesh, and tar, a very random mix of materials. Stone was missing around it. The rubble foundation wall had been displaced to the floor. Over on the right image, that tape and tar was removed, and we have an oval-shaped hole. The edge of the hole were rusted and corroded, severely deteriorated. So the assignment proceeded, and it eventually got to litigation. We went back to the site for a second time. The pipe had been repaired with PVC piping. It was cast iron. It wasn't the greatest repair. The cast iron had been removed, and it was broken into pieces, and you can see it was severely corroded. A volumetric loss of metal, rusting, etc. Basically, the facts that we have were the plumbing contractor had been to the property several times in the past, including addressing leaks with the same sanitary pipe that had reportedly experienced the sudden break. The owner and the owner's representative also claimed first-story flooring damage on top of it from water that was tracked through the area. However, our inspections indicated there was no evidence showing any wastewater was tracked from the basement to the first floor, and there was no moisture-related damage found to the flooring, which exhibited typical signs of just long-term wear and tear. Ultimately, we ruled the cause and subsequent moist conditions contained in the utility room was long-term corrosion along the invert of the cast iron pipe. This had moved to arbitration in Philadelphia, and this property owner ultimately didn't show up and the case was dismissed. Here's a claimed water damage to wood flooring at a property. Here we have, it's inside this room, inside this window here where the flooring damage was claimed. We have a front porch with an extended overhang covering and protecting the sides and the front from sunlight precipitation. The window was slightly open with the screen present, and that acted as an additional barrier layer from precipitation and sunlight. Here's the inside flooring. We had an HVAC vent in the front area, and there was no visible water damage, such as crowning or cupping or anything of that nature. Scratch marks on the surface were consistent with wear and tear, and abrasive marks from furniture legs, which were in the room and being moved all over. Dog nails, which there were 2 large dogs in the home, and other factors. Here's the wall finish around that window. We got trim and wainscoting, and that was absent water standing or any indications of water damage or water trails coming in through there. The subfloor and joists beneath in the basement below were free of any water staining. Given that the front dining room windows were covered beneath an extended pent roof, the rainfall consisted of near horizontal trajectory would have been needed for water to enter the windows. We looked up weather records, wind direction on the date of the claimed incident. The wind direction was 300 degrees, so angled toward the southeast. So we would have needed a 225-degree angle to promote water intrusion. So the wind actually went the opposite direction, which was needed to get to even possibly have precipitation aimed towards the windows. And the wind speed, maximum gusts were low. So the rain would have been falling at a vertical trajectory. The average temperature, the incident was in January, it was 34 degrees. The windows likely would not have been opened. And then there were the screens as well. And had sufficient water volume entered the windows to result in damage, it would have been expected that moisture damage would have also taken place to the windowsill, wood trim, and paneling, the wainscoting. But there was no such. And the remainder of the first floor hardwood flooring was observed in similar conditions, identical throughout, uniform throughout the first floor. And then conflicting information revealed in deposition transcript and history of the site claims, for which there were many, as we found out. Other random claim damage throughout added by the property representation that were not claimed by the owner. So here's an example of what real water damage will look like to a floor. You have cupping over on the left side, and you have crowning on the right side, and an image of that, which will be a cross section here. Cupping is more of a smile, crowning is more of a frown, and this is what you would expect for water damage to a floor. And as I said before with the other one, both that the sanitary case, the sanitary sewer, and the flooring case went to arbitration. The first one, the sanitary, the owner never showed up, so it was dismissed. The other one, the flooring case, we won. Our side had won. So here's another property, claimed wind damage. You see a tarp on the roof, so a contractor had obviously been there at least once, if not more. As you can see in these photographs, you have roof shingles with very, very odd fracture patterns, vertical and irregular shaped fracture patterns. Very, very odd. And they were claiming wind damage. You can see the tears, diagonal, jagged, turning. Here's more. We were able to basically put some back into where they had belonged, like a puzzle. Very beat up. Damaged shingles as a result of wind would display damage patterns associated with uplift. Horizontal creases or tears, fractures left to right along the intersection with the overlying shingle would be expected. But for this roof, the shingles, along with some ridge shingles, display vertical front to back and very irregular shaped, jagged fractures. And further, if wind force was of great enough magnitude to cause the fracture, then the detached shingle would also be relocated from the roof. However, the roof contained detached shingles of those irregular fractures remained lying on the roof structure. Several sections of the torn shingles were observed adhered to the underlying shingle at the location of the self-sealing strip. and the balance of the shingles were relocated from the roof slope area. If wind wave caused the damage to the shingles, then the entire shingle would have uplifted and detached, not fractured in a regular pattern. Basically concluded that the damage was not the result of wind forces, but was rather the result of manufactured tears to the asphalt columns and shingles. And the cause of damage was consistent with manufactured damage, not associated with any weather-related phenomenon. This had proceeded to litigation and fraud, of which I never found out the ramifications, but it got pretty serious. Here's in contrast, here's examples of legitimate wind damage. On the left side, you have a crease shingle where you see the crease along the top of this, and the other is a torn shingle where it had torn in a horizontal manner, as we discussed. Okay, so here's another claimed incident of a trip and fall at a Sunoco station. We had the claimant, and this is using Google Street View, a November 2018 image, to be able to go back and look at the conditions of the paving, of the asphalt paving, the concrete pads, the islands for the gas stalls. The gentleman had indicated that he had left the building and tripped heading back to his vehicle after purchasing something in the store. Depositions and transcripts of the claimant indicated tripping on the uneven pavement, like I said. We were able to obtain video surveillance, which showed the claimant looking at the screen of their cell phone while walking back to their car, and subsequently tripping over the stall islands around the pumps by their car. Examination of the site revealed a section of uneven pavement well away from the area of the fall in the surveillance video. There were no eyewitnesses at the site, and the station worker was inside with another customer at the time, so they did not see the incident. However, the video surveillance clearly showed the deliberate deception in the trip and fall claim. Here's an example of uneven walkway with legitimate tripping hazard versus an even and smooth walkway and pavement. On the left, you have this concrete walkway between a building and a road, and you have a good uneven displacement here between side-by-side concrete walkway panels, and that is a tripping hazard. And this can be remedied either by removing and replacing with new concrete, or it's allowed, at least in many municipalities, depending on the state, where they can grind this and smooth it out to a very light slope, so it's a smooth transition. Over on the right is that smooth type transition of a walkway and abutting roadway surface. So you got paving, asphalt paving, and concrete that's smooth and free of obstructions or tripping hazards. Here's another case study. Crack of a brick masonry wall. There was neighboring highway construction that took place in June of 2021. Property representation claimed that cracking to brick masonry resulted from the highway construction. The building owner occupied the building since 2010. However, research of historical street side images of the building, including this image taken in September 2019, exhibited cracking above and next to the front door here, similar to what they were claiming. So it's clearly visible at any time a person entered the building or exited, and the owner had owned it since 2010. And this is years prior to the highway construction. So just this Google street sign image was able to refute that claim and prove that they were putting in a fraudulent claim. Here we have a vehicle impact. There's real damage, obviously, and exaggerated damage. This pickup truck backed into the front wall elevation of this dwelling. On this top left, we have real damage from real related damage from the vehicle incident to the front exterior wall. The framing, the finished materials, clearly fractured and displaced inward. Here we have the rear wall of this front room, which lacked cracking or other damage in the impact. As you can see, the wall-to-wall, wall-to-ceiling joints are smooth and free of cracks. Now we have a room that's far away from the impact. It's kind of hard to see in this image. At the rear of the dwelling contained weathered cracks upon our observation and debris with rounded edges. And like I said, it was farther away in the rear of the dwelling. And it's outside the energy dissipation path. So the vehicle hit the front, the energy of that impact was transferred to those walls, the ceilings, and it would produce cracks as long as the dwelling materials resisted that. So it was enough to damage this and sides of this, but the rear of the front room, vehicle impact. Therefore, the rear of the dwelling wasn't expected to sustain any damage as it was farther away, and indications, the conditions of the cracking confirmed and supported that they weren't new cracks.
I have a question.
Sure.
Are you able to make a determination, or are you called upon to make a determination whether a building is inhabitable or if they have to tear it completely down? Is that part of?
Yes. Yeah. Condition assessment basically is it repairable?
Right.
Yeah. So was that deliberately misleading? Did the owner never notice it before? Cracks in areas of structure they rarely visited, such as an attic or crawl space. And then you have a condition of decayed wood. Sometimes decayed wood isn't visible until there's damage and the finished material is removed and they find decayed wood. Other times it's in a highly visible area and it's decayed wood and they're claiming damage, sudden damage, and you refute. That's not realistic. That's deliberately misleading. Does it constitute fraud? Well, they're being fraudulent about their claimed damage at the time. So what you want to do is you want to interview, check building history, prior ownership, construction dates, permitting applications, repair work that's been done over time, when it's been done, type of repair work, building envelope, structural, and then check available online data. It's better with exterior damage, of course, but sometimes you can get interior chronological data to compare. Here we have an example of hail damage. Where is it? So which one's hail bruise and which one's deliberate damage? Can you guess? Can anybody guess? They look pretty similar depending on the clarity and how far away. So this one, which was on the left, is deliberate damage. This is fraud. You can see the circumference of this is a quarter. I believe it's a quarter. The striations, the corrugations on the edges, the circumferential edges, you can see those going through, the striations through there. And that's a common manufactured damage, fraud damage too, that they try and make appear as hail. Hammers, you'll see, but this one's very common. And here's a real hail impact consistent with hail. You have an indentation right here. It's hard to see, but you have fractured reinforcing mat. You lift it, you can check the underside and see that. This you could see from the surface, but you could lift it, feel the underside, and check that. Here's some more scenarios. Premiseless liability cases, where you have nearby construction activities. You could have roadway utility work, new building construction. They can claim damage to your building from roadside utility work. They're replacing sanitary sewers, water mains, storm sewers, and they're claiming damage to the property from that work. Building a new hotel. I had a Brooklyn one, Brooklyn, New York. Building a hotel next door, but there's good spacing between these old brownstone buildings, condominium buildings, 100 years old. They're claiming cracking damage settlement from the hotel construction, which is not legit. There's types of beneficial data you use, obtain available vibration monitoring data. of heavy equipment, such as pile drivers, if they were used, rollers, bulldozers, to analyze peak particle velocities. And that PPV refers to the movement within the ground of molecular particles. It's related to vibrations and measures velocity and frequency variables. Now, there's low-level data values that help support findings of unrelated damage. And it's been studied over time and tested that there's thresholds of where you would expect damage to, whether it's exterior cladding, brick masonry, interior drywall finish. And you get that supporting data from something like this, where they're claiming construction work is resulting in cracking of your building. You have monitoring data from the contractor that can dispute and support your claim, along with, you have Google Street Side images showing those step cracks coming from the corner trim 3 years prior to the claims incident of a doorway that which they enter and exit daily, and you have, fraudulent situation going on. And the procedures, like I said before, conduct on-site examinations, interview the property representatives, and perform research and review of site data. So here we have various cracks discussing on walls, aged, repaired, or really recent. On the left, you see cracking of a floor slab with prior sealant material. They're saying is new, but there's prior sealant in it. This one has paint finish within the crack edges, the inside crack edges. You see paint finish. So that's been there before. The right one, the edges are sharp. The exposed gypsum board is bright and fresh, which is consistent with a new or recent crack. Here you have a CMU, concrete masonry unit wall. The inside edges were painted, so it cracked before it was painted. So this is old damage. You have on the right, this is called corrosion jacking. Typically, you'll see the fracture with this extending horizontally, but sometimes vertically, or many times stepped. What happens here is the steel lintel at the top of windows or door frames corrodes, and the volume of that rust is greater than it was before. So it's called corrosion jacking. It expands and winds up cracking the surrounding masonry. And then other types of insurance claim fraud, automobile damage involving subterfuge, deliberately causing an accident or impact damage to a vehicle. And it could include additional property damage for the same claimant or a separate entity. Was it deliberate accident in a garage that was damaged and they wanted a new garage? You have to look into interviewing any video evidence that you have. Could be multiple parties involved if it's a vehicle in a separate structure for a separate entity. Inflation, damage inflation includes vehicle and/or property damage which pre-existed the accident. Was there a prior accident or impact damage to the vehicle? You have a prior claim that was paid but not repaired. Then a new claim with prior claim damage is included again, maybe with a new insurance company. Hail dents, are they really hail? Are they manufactured similar to the shingle? And then the common investigative modes as property damage, similar. Check for video surveillance, residential, commercial, industrial. Interview claimants and claimant representatives, any contractors involved. Check for invoices, mechanics, automobile mechanics that worked on the vehicle. Interview eyewitnesses, check aerial and street side imagery. This actually is useful for vehicles too. Depending on the age and the clarification of the images, you can get their home and an image of the vehicle at the property that they live. Request and review prior auto shop invoices, like I said, repair work, and insurance information. Fire origin and cause investigations. There's fire damage deception, incendiary arson, which is most serious. Inflation, that includes damage which pre-existed the fire. neighboring properties claiming damage due to a fire in another structure, and deception from contractors with chimney damage, long-term versus sudden, which have been seeing a lot of. Here's a fire in the top of the stairway, a landing. This is around a fireplace. Here's an example of a claim of soot damage to a separated by 4 dwelling row homes in between from where the fire. Thorough examination of the removal of finished materials with clean surfaces. So here, cut a hole. A view within a kitchen ceiling bay revealed a historical fire at the dwelling that was located 5 row homes to the north of the dwelling. So this was the one claiming the soot damage. We moved drop ceiling tiles, exposing ceiling bays with the joists and subflooring charred, blackened, which indicated there was a prior fire at this other residence. You see drop studs here to hang the drop ceiling that was used to cover and repair the prior damage. So this is claiming soot damage. We don't see it throughout. We removed finish in some rooms to check the wall bays. And using a sponge, we wiped it on the masonry, and discoloration and a chemical composition that was similar to soot was on the sponge. However, the inside surface of that removed drywall had none when you wiped it on the sponge, nor the outer surface, which indicated that soot was from that historical fire. This drywall was new to cover the damage to the walls. Some of the soot from that prior fire remains on the masonry, but they're putting in this new claim that the opportunistic claim that the fire 4 homes or 5 homes away resulted in new soot damage to their property. So here's a recap of common scenarios that involve potential fraud. A real incident took place, such as a tree impact, a vehicle impact, slip and fall, pipe leak, flooding, but the damage is sizably exaggerated and false damage is claimed. There's known pre-existing damage by the owner and or owner representation, i.e. damage conditions were present prior to the reported incident date, but the damage is pretended to be new. There's no incident that actually took place, or an incident was fabricated, but the damage conditions are being claimed. A continuation of that, there was an incident that took place somewhere else, such as, and this happened a lot during, especially if you remember Irene and Tropical Storm Lee, and then Sandy. Hurricane forces were experienced at the Jersey Shore, but falsely claimed that sites, especially in Pennsylvania with no such conditions, hundreds of miles away, very opportunistic and turned into fraudulent claims of hurricane damage using all those sources we discussed: aerials, street side images, video surveillance interviews, prior damage conditions, to dispute those claims. It's found that there exists a recorded history of site claims at the same property. For example, historical roof claims submitted to Company A. That claim was paid out, but the roof was never repaired. Then years later, a similar claim for the same roof was submitted to Company B, which we've seen. So they submitted a claim for wind. It was paid out. They never repaired it. Moved on to a new insurance company, submitted the same claim years later. The roof was never repaired, same roof, and they were submitting a similar wind claim. So my final thoughts: most of the time, us engineers are requested to evaluate the cause. Damage may be along with scope or extended damage. The evaluation typically involves inspecting a property, interviewing or discussing background information with property reps, conducting any necessary review and research, and preparing a report. The evaluation could include us opining that the damage is consistent with manufactured damage, inflated damage, or damage unrelated to the reported incident. We may submit a report indicating the suspected subterfuge by the property representatives. However, many times us engineers may never find out about any continued investigation into the closing status, fraud, and/or ramifications of the claimants. But hopefully our thorough analysis helped provide the proper resolution. That's the extent of my presentation. This is my contact info, phone number, email. I'm licensed in all those states around PA and New England. If you ever need any assistance with a claim case.
One of the kind of questions people are going to ask, will your presentation be available at all?
Yeah,
Okay.
I can make it
So we
available.
can get that to the.
Brian, our business manager with Hague, did you want to talk about the impact event we have? We have an impact event in October. He can better speak to that than I can.
Sure. Thanks, David. Yeah, I just want to talk briefly. We have an event on October 15th at the Philly Expo Center across the street at Arnold's Family Fun Center. We're going to be offering CE credits for adjusters, CLE credits for attorneys, and the theme is impact. Every year in October, we have an event for our customers and people that want to come from the insurance industry. Last year, we had a live burn at the Philadelphia Fire Academy. This year, it's at Arnold's Family Fun Center. I can send an email to anyone that's interested, or if you're comfortable sending it out or giving me the list. And this year's theme is impact. We're going to have junk cars pulled into each other, pulled into structures to demonstrate impact, some SIU topics, as well as forces of nature.
Hurricanes, things like that.
Yeah, so should be a fun event. It's an all-day event. We'll provide breakfast and lunch. And again, there'll be credits for adjusters and attorneys. So if you have any questions, feel free to talk to me afterwards. Thank you.
Thanks, Brian.
Yeah. Okay, thank you, Dave and Brian. They'll be here. So Al has the food set up in the main lobby. You can come out, mingle, meet with each other, go over some stuff, meet with Dave and Brian if you have any questions of them. A little bit of a different forum here, working on it. That's why I asked about the presentation. He can get you a copy of the presentation. I'll get a copy of it, and then I can forward it to anybody who would want that. Just contact me. Said food in the lobby. Upcoming meeting December 9th. Pasha and IASIU, bring a gift. Also the Dream Drive, if you want to donate to them as well. And Bob Horsch will donate to them. So we'll have 2 organizations this year that we're giving to. And that should be about it. I know, I just want to make sure I got everything. Oh, one of the other things, we had thought about doing a one-day seminar for the DelVal chapter IASIU. We had planned it in March, but that we don't want to conflict with IFPA being the next month. So we're probably going to look in June for a one-day seminar somewhere to get CE credits. So if you know any vendors or anything like that that would like to present at that, we'll do a one-day seminar. We'll pick a venue. And so I'm working on that if anybody has any ideas. And that's it. Thank you. And thank you for your attendance. Thank Bob Horsch for providing the venue. Thank Al from NICB for the food and the presentation from Hague. Thank you, everybody.